Greetings to all of you watching this video. Today, let us learn a bit about systematic documentation of invention. Once you have made up your mind to file for a patent and the first meeting with the attorney or agent is fixed, one of the most important things to be understood is how to document the invention details in a systematic manner. What all shall be documented and how much details are enough has to be made clear before you initiate the process of filing for a patent. Though one often feels lazy writing the disclosure of the invention, honestly speaking, there is no substitute to documentation. Sooner or later, you have to document the invention so that the interaction with your attorney or agent is comfortable and you waste less time in the process. It is always advisable to execute non-disclosure agreement or NDA with the attorney to whom you will be disclosing the invention. The three most important points to be taken into account at the time of documenting the invention are identification of novel elements in your invention or what is to be claimed, existing technical problem, best mode. Let us understand these points one by one in detail. First thing to be done is identification of novel elements in your invention or what is to be claimed. Patent is a techno-legal document and you get protection over the items or elements that you claim in a patent specification. Therefore, it is imperative to identify novel elements of the invention and find out the ways to claim them in the specification. Once you are clear about what to claim, the detailed description of the invention in patent specification revolves around such novel elements and helps you to fine-tune the invention as well as highlight the novelty of the invention. The best way to identify novelty of the invention is to perform a thorough global patent search known as a prior art search and assess novelty of the invention by comparing it with existing prior art. In order to be patentable, your invention should have novelty, inventive step, and industrial utility. While novelty is assessed against existing prior art, one of the ways to assess inventive step is identification of the technical problem and the solution you provide. The Indian Patents Act 2005 in Section 21J and 21JA respectively states that the invention means a new product or process involving an inventive step and capable of industrial application, and inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art. Hence, you should always be aware of existing prior art to precisely know novelty of the invention and technical problem that you intend to solve by means of your invention. At the time of documentation or disclosure of the invention, giving background of existing technical difficulty and need to have a solution that your invention is capable of providing is very important. Clear mention of existence of the technical problem makes it easy to establish the need to have a solution for the existing problem. Disclosure of best mode of working the invention in the specification is an essential part of any patent application. A complete application should start with a preamble. The following specification particularly describes the invention and the manner in which it is to be performed. This clearly indicates that the inventor has to describe the best mode of working of the invention, and at the same time, the disclosure has to be complete without any gaps in the process. Section 10 of Patents Act 1970 clearly states that every specification, whether provisional or complete, shall describe the invention and shall begin with a title sufficiently indicating the subject matter to which the invention relates to. Every complete specification should fully and particularly describe the invention and its operation or use and the method by which it is to be performed. Disclose the best method of performing the invention which is known to the applicant and for which he is entitled to claim protection, and end with a claim or claims defining the scope of the invention for which protection is claimed. The disclosure of the invention should be sufficiently enough that a person skilled in the art shall be able to achieve the results without further experimentation. Incomplete documentation of the invention by inventor resulting in incomplete disclosure of the same in patent specification may be one of the grounds for patent revocation or invalidation. Hence, it is important to disclose complete process that is executable. Specifications often consist of background, description, claims, abstracts, and drawings. Stepwise documentation of the invention assists your agent to draft specification in a better manner. You always prepare flowcharts or drawings for easy understanding, even though the drawings submitted by you often would undergo complete redoing of the work to match standards of the respective patent office. Let us conclude this video by stating that documentation or disclosure of the invention is an integral part of the process of patenting. There is no substitute to it. The quality of the patent specification primarily depends upon the precise and clear information you provide to your patent agent. Even though it takes 1 or 2 days extra, it makes a lot of sense to spend some time and write the invention description patiently. Thank you for watching this video. Check our website www.originipa.com for more such videos related to IPR. Do get in touch with us in case you need further information or assistance at our office, number 35, First Lane, Vaisya Bank Colony, BTM Second Stage, Bangalore 560076.